Hi class, it's me again for another video presentation with regards to our subject. But before we proceed, I would like to say some reminders that if you have a question, you can just type it on our comment section, or if not, you can save it and you can raise it when we are going to meet in our synchronous session. So please watch till the end. For this video, we are going to talk about Unit 1, and it is all about dispute resolution in law enforcement. So, let's begin. In this slide, we have a question. It says here, what is a dispute? So, we have here a definition. It says here, a dispute is a conflict or controversy. So, it is a literal definition. We have here also, it is a conflict of claims or rights. Or in other words, it could pertain to civil cases. We have here also subject of the litigation. So ito yung kaso na pinag-uusapan or sinosolve dun sa korte. That could be. And then, it is an argument or disagreement. So ibig sabihin yan, we can say that we are always or we often involve ourselves in disputes. Right? So kahit sa eskwelahan, nakikipag-debate tayo or nakikipag-away tayo dun sa ating mga kaklase. Okay? Nakikipag-away tayo sa mga teachers natin. Okay? Usually, meron tayong hindi pagkakaintindihan. Diba? And then, we have here also an example. Sabi dyan, it is a labor dispute or land disputes. So, ito yung pinaka-common na klase ng disputes. Just like in workplaces, wherein employee versus employers. Right? Dahil sa sahod. Okay? Hindi tamang pasahod ng employer or yung employee mismo hindi niya ginagawa yung trabaho niya. That's why umaabot na sila sa hindi pagkakaintindihan. Ayan, hanggang sa gusto na nilang magdemandahan, pumunta sa korte. Okay? But before they can go to court, meron yung tinatawag natin na outside the court na proseso para tayo ay or para sila ay magkaayos. Or in other words, yung tinatawag natin na alternative dispute resolution. Or sa iba, sinasabi nila na appropriate dispute resolution. Okay? So isa sa magiging paraan nila is yung tinatawag natin na mediation or pwede namang arbitration. Or in other words, pwede naman negotiation. So yung differences natin, differences ng mga yan, we are going to discuss further. And then, we have here land disputes. So ito yung common naman sa mga magkakamag-anak. Okay? Especially yung mga malalawak na lupain tulad ninyo. Diba? So, kung minsan hindi na ninyo kinikilala na kapatid yung mga kamag-anak ninyo or pinsan ninyo. Diba? Hindi na ninyo kinikilala dahil sa away sa lupa. Okay? Sabi nila, sa kanila daw yung lupa. Dahil yung talagang may-ari dun is yung nanay nila or tatay nila. Okay? Or sa nanay nila binigay ng lola ninyo. Parang ganon. Okay? So, dahil sa hindi pagkakaintindihan na yan, minsan hindi yan ay kahit magkakamag-anak kayo, nagdidemandahan kayo. Okay? Pero hindi usually dire-diretso sa korte ang mga disputes na yan or yung mga di pagkakaintindihan ng mga yan. Pwede naman na yan na sinusolve nila dyan sa labas sa tinatawag natin na alternative dispute resolution. Next, we have here a question. What is a dispute resolution then? We have here another definition. So sabi dyan, it is a process or these are the processes used to resolve the dispute or the conflict or the claim. Okay? So an example is litigations or lawsuits. Pero sabi ko nga kanina, hindi lang lagi sa korte kasi litigations or lawsuits na yan, it is being conducted doon sa korte. Okay? It is a procedure or it is a process that is being done inside the court. But here, meron tayo dito yung isang example as I've mentioned a while ago, yung sinasabi natin na alternative dispute resolution or appropriate dispute resolution. So, parehas lang po yan. Alternative, appropriate, parehas lang po yan na tinutukoy natin ay dispute resolution. So, always keep in mind, ang kaso or ang dispute, hindi lang po natin yan nasusolve sa korte. Okay? So actually, there are lots of procedures na pwede nating gawin para hindi na umabot sa korte. Why? Kasi kapag pinunta natin yan sa korte, of course, mas malaki yung expenses natin. Aside from that, time, di ba? Mas makukuha yung time natin or mas mauubos yung oras natin dahil sa pag-attend ng hearing dun sa korte. Okay? And take note, sa korte, hectic yung schedule nila dun. So, kunwari, nagkaroon kayo ng hearing na ngayon, next na naman na hearing nyo is sigurado next month yan. So, maghihintay ka na naman ng next month para lang i-hearing na naman yung dispute ninyo. Okay? So, better, you should avail or you should go with alternative or appropriate dispute resolution. So, it is more on practicality yung ADR. Okay? So, yan yung dispute resolution. Take note of that. Next, firms usually involved in dispute resolution. So, ano-ano nga ba yung karaniwan na i-involve kapag merong nag-aaway na pamilya? So, sino yung usually na agency na involved sa mga yon? Or sino yung opisina na, or kaninong opisina yung usually na involved doon pag merong away pamilya, away sa lupa, away sa trabaho, away sa mag-asawa, and lahat-lahat na. So, meron dyan yung barangay. Okay? Usually, ang barangay yung isa sa unang nilalapitan ng mga tao or ng mga residents na merong conflict with their neighbors. Okay? So, karaniwan dyan, away mag-asawa. So, hindi nila ma-solve ng dalawa lang sila. Hindi na makontrol yung emotions nila. Kaya yon, walang patutunguhan. Kailangan nang meron nang mag-mediate sa kanila. So, nandyan si barangay chairman. So, yan ay nire-refer nila dun sa barangay mismo. Okay. Another one, we have here the police or the law enforcement agencies. Right? So, meron dyan nag-aaway sa lupa. Okay, kung minsan yung away sa lupa involved na ang patayan. So, in terms of killing between different people, sino na ang pwedeng mag-mediate yan? Si kapitan ba? No. Pero na lang kung si kapitan ay merong baril para pagbabarilin na lang kayo kapag kayo ay hindi mag-usap ng maayos. Okay, so anyway, just kidding. Usually, if it involves killing, ang agency na kinakailangan natin dyan ay ang PNP or law enforcement agencies natin. Okay, so yan. Next is yung korte. So, kapag hindi yan na-solve sa barangay, that's the time we can proceed to court. Hindi natin kaya sa barangay. Hindi kaya ni kapitan na pag-ayusin tayong dalawa. And then we tried also to hire or we decided also to avail arbitration. So, we decided to choose an arbiter. Pero, hindi pa rin na-solve. Okay? So, kunwari, or sabihin natin merong decision yung arbiter, pero yung kasama mo, or yung kaaway mo, ayaw niyang tanggapin yung decision ng arbiter. So, yan, pwedeng idinig yan sa korte. And then, yung korte yung magsasabi, oy, ikaw, ito yung napag-usapan naman ninyo na kayo ay mag-undergo ng process of arbitration. But why? Now na hindi mo tatanggapin yung decision ng arbitrator. Okay. So, with the power of the court, we are enforcing the decision of the arbiter. So, kailangan mong gawin itong decision na ito. So, kailangan mong bayaran si Mr. X, kunwari. Parang ganun yon. So, ganun yung proseso ng arbitration. So, arbitration award or yung sinasabi natin na decision ng arbiter, pwedeng i-enforce yan ng korte kapag yan ay hindi nirespeto ng both parties or ng isang party. Okay? So, yan yung karaniwan na involved in dispute resolutions. So, hindi lang Yang tatlong yan, marami pang ibang involved na agencies. Pero yan yung pinaka-common. Next. Actually, in Philippine National Police also take note in order to respond more on those kind of disputes and actually incidents also. So dispute is different with incidents. So usually PNP is also involved in incidents or the occurring events, okay, just like hostage taking and so on. Pero yon, just to remind you, the new operational support units of the PNP. So take note, these are the specialized units of the PNP in order to address or to respond with those kinds of disputes or incidents that are being that is existing in our society. Okay, especially dyan meron yung for hostage taking or kidnapping incidents, meron dyan yung PNP Anti-Kidnapping Group. So 14 units na po or 14 operational support units na po tayo. So just keep that in mind. Okay? That is just an addition. Next, we have here some indigenous traditions of dispute resolution. Number 1 dyan ay ito. Itong Gakaka court system. Okay, so itong Gakaka court system, it was created because of the case of genocide. So, if you read or if you research more about this, so involved dito ang milyong-milyong katao na pinatay. Okay, so there are lots of people that were killed during this or in that certain place in Rwandan. Okay, that is in Rwandan, somewhere in Africa. Okay, and then perpetrators, so yun, aabot din sila ng daan-daang katao. Okay, so in order to try them, kasi yung 100,000 na katao na yun, hindi nila kayang masolve in a certain court. Okay, and that is a far-flung area. Okay, or it is considered to be as uncivilized. Okay, or hindi masyadong urbanized na place. That's why they created a Gakaka court system. So makikita nyo dyan sa picture wherein it is conducted not inside a building or not inside a court. Okay? So, yun, yung mga nandun sa harapan, they are somewhat called as the juries. Okay? Parang sila yung in charge to try, hear, and decide those involved in that particular case. Okay, the Rwandan genocide in 1994. So just imagine there are millions of people who died or who were killed by that certain perpetrators. Okay, so that is the Gakaka court system. It happened somewhere in Rwandan. Okay, Africa. So that is only one indigenous traditions of dispute resolution. And actually, if you read or if you watch videos about this, still yung pakiramdam. Kasi 1994 pa lang yan. Yung mga perpetrators or yung mga biktima dyan, yung pamilya ng mga victims during that time, still living nowadays. So yun, maririnig mo sa kanila na still, meron pa rin yung hate nila dun sa mga taong gumawa nun or pumatay dun sa mga kalahi nila or mga kapamilya nila. So meron pa rin yung hate na yun. So in order to heal, isa rin sa purpose ng Gakaka court system na ito is para ibalik or para sagutin or in other words para paghilumin yung sugat ng mga namatayan na yon, okay, para mawala yung hatred nila dun sa ibang lahi na yon na gumawa or nag-commit ng large scale genocide na yun or yung genocide case na yan. Okay, so yan yung sa Gakaka court system. Next, still another indigenous tradition of dispute resolution. Ito naman, it is found or it is being written or it's said to be in Kalinga province. So Kalinga province is one of the provinces in Cordillera. So, tinatawag nila itong budong or budong. And in English, it is termed as peace factor treaty. Okay? Or peace pact or treaty. That is not peace factor. Sorry for that. That is peace pact or treaty. So it is still somewhat like a judicial system, and it is considered indigenous or ADR. Actually, this is not, according to the stories that I've heard currently, wala na yung ganto. Okay? Kasi civilized na rin yung province na yan. Hindi na uso dyan yung tribal wars na sinasabi nila. Although yung tribal wars, may madilim yan na karanasan nila during the past. Pero ngayon, Kalinga province is a peaceful province actually. So yun yung budong na ito, ang ginagawa nila dyan, meron yung tinatawag nila na peace pact holder. So ito yung inappoint ng pangat or yung tribal leader nila, and then siya yung hahawag ng peace agreement na pinag-usapan nila dun sa ibang tribo. Kasi sa Cordillera, meron yung tribo dyan. Okay? So, meron yung, just like sa amin in Benguet, we have the so-called Kankanay and Ibaloy. Okay? So, that is different tribe. So, I don't know in your places if you have such kind. Okay? So, there, usually yung mga tribe na yan noon is magkakaaway-away. So, involved dyan kapag meron yung nakapatay yung isang membro nakapatay ng ibang membro or membro ng isang or another tribe. Okay, kunwari, si Iskaran, kabilang siya sa isang tribo, and then nakapatay siya ng membro ng ibang tribo. So, dahil sa siguro, yung taong yon naabutan niya na ninanakaw yung kalabaw niya. So, dahil sa hindi na niya mapigilan yung galit niya, hindi niya naisip yung magiging consequences niya. Kaya, ayun, kinuha yung sinibat niya yung tao, and eventually, namatay. Okay, so, yan, if babalikan natin yung mga kwento nila noon, kapag merong ganyang events, usually, kung buhay yung kinuha, buhay din yung kukunin. So, pupuntahan nila yung tribo na yon, okay? And then, usually, dinadaan nila sa patayan. Pero yon dahil sa lumabas itong budong na judicial system nila, ang ginagawa na lang nila, nag-iipon-ipon sila. Nagtitipon-tipon sila, and then, pag-uusapan nila yung nangyari. Okay? And then, hindi na nila kailangan magpatayan dyan. Mag-uusap na lang sila. So, ito ang dapat gawin nung nakapatay na tao. Okay? So, whether magbibigay sila ng conditions. But actually, sa mga libro, hindi natin makikita yung mga conditions. Pero usually, siguro it involves materials. So, yun. Magbibigay sila ng conditions. And then, yung tao na yon na nakapatay dun sa kamiyembro nila should abide with those. Kasi kung hindi, sigurado yan, it will cause, again, another war or tribal war between them. And then, of course, it is part of the member to convince those, yung kamembro nila na yun, gawin kung ano yung nire-request ng ibang tribo para hindi na mag-cause ng war. Okay? So, meron dito yung peace pact holder na ito. So, siya yung naghahawak ng peace agreement with the another tribe. So, the two tribes agree to ally with each other. So, yun. And then, tinatawag nila din, meron sila yung tinatawag na pagta or written laws. So, yun. Yan yung tinatawag nila na budong. Okay? Or budong. That is budong actually. So next, we have here the so-called trial by ordeal. So it is during the ancient times. I know that you have already encountered this. So meron tayo yung boiling water ordeal na tinatawag nila, and then meron din tayo yung cold water ordeal na tinatawag nila. Okay? So, sa boiling water ordeal, kung makikita nyo dito sa litrato na to, yan ay itatali yung perpetrator or itatali nila yung suspect, kamay and then paa, and then ihahagis sa river. Okay? Doon sa ilog. And then kapag nakatakas or nakawala yung tao, nag-survive siya doon sa event na yon, then he is considered as innocent. So actually, trial by ordeal is not a punishment. So hindi yan punishment. That is actually a judicial system. A method in order for them to determine who is guilty or who is innocent. So yun yung pagkakaiba ng punishment sa judicial system. So hindi pag sinabing trial by ordeal, that is a punishment. No, it is not a punishment actually. It is just a method in order to determine who is guilty or not guilty. I hope that you keep that in mind. And then we have here the boiling water ordeal. That is very simple, wherein the hand of the perpetrator or the suspect, yon, isasawsaw niya or ilulublob niya dun sa kumukulong tubig. And then if the perpetrator or if the suspect was not hurt, then he is considered as innocent. But if he is hurt and then yung kamay niya is nasunog or nalamaw in slang term, of course, he is considered as guilty. So that is because during the ancient time, they still believes on gods and goddesses. Kaya ganyan yung methodology nila. Because they believe that if the person is really innocent, then the God or his God will save him from that consequence or from that event. Okay? So that is trial by ordeal. Now we are going to proceed with alternative or appropriate dispute resolution already. Okay, so we have here the first one. The so-called negotiated ruling making or yung reg-neg in a shorter term. So ito ay an example of this is when the governments and regulated industries negotiate the regulations before they are promulgated. So in other words, ito yung tinatawag natin na negotiation. So ano yan? Meron kayo dun sa Philippine Constitution nyo, napag-aralan ninyo yung the government shall not take private property, blah, 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 without just compensation. Sinabi doon, di ba? So, in order for that, kailangan nilang makipag-negotiate, just like an example with the road widening. So, yung bahay ni Iskaran, or ni Mr. Iskaran, is nasa gilid ng kalsada. Nagkataon, yung project ng DPWH or ng government, nakuha yung property niya. Let's say yung bintana niya, yung part ng, or yung side, okay? Yung maliit na parte ng bahay niya, makukuha ng road widening. So with that, the government should, or the legal service of the DPWH should coordinate or should talk with or should negotiate with Mr. Iskaran before they are going to take that property in order to implement the road widening. So yun. So paano? Ano yung i-offer nila? Just compensation. Karapat dapat na kabayaran. So hindi pwedeng yung government kukunin para ito sa road widening natin. Pasensya ka na. Hindi pwedeng ganun. So with just compensation dapat. Okay? So they should negotiate and dapat mapapayag nila yung nagmamay-ari doon. Okay? Or mapapayag nila si Mr. Iskaran. That is just one example. So yan yung reg-neg. And we have also here the shorter term med-arb. Or in other words, mediation arbitration yung mini-mention yan. Sa mediation and arbitration, later on meron yung separate na slide wherein we are going to discuss in detail yung mediations. Pero sa ngayon, sa mediation kasi, dyan ay neutral lang yung third party. Okay? Meron yung papagit na dyan. So, parang sa barangay, si barangay chairman. Magpapagit na siya or siya yung mag-a-act as a referee. Pero yon, wala siyang power to decide kung sino yung nanalo or wala siyang power to give an award. Okay, so ito, kunwari natapos yung mediation nila, ikaw, Mr. X, kailangan mong bayaran si Mr. Y. Hindi niya pwedeng gawin yon or wala siyang kapangyarihan para utusan yung si Mr. X na magbayad kay Mr. Y. So yan yung mediation. Ang gagawin lang niya, mag-intervene lang siya. Okay? Parang magko-coach siya or magre-referee. So parang sa boxing, hayaan niyang maglaban yung dalawang boksingero. Okay? So anong gagawin niya? Panoorin lang sila and then make sure na yung isang player or isang boxer wala siyang nilalabag or hindi siya nandaraya. So yun yung parang trabaho ng mediator. Pag hindi gumana yun, that's the time susubukan nila ang arbitration. So ano naman ang arbitration? Sa arbitration kasi, meron na dyan meron dyang third party. And of course, pinipili yan ng both parties. Okay? So hindi dapat basta-bastang ma-assign ang arbitrator dyan. Dapat pinag-agreean yan ng dalawang party. Okay? So yes, sige, payag ako siya yung gawin nating arbiter natin. And actually, meron yung batas din na sumasakop dito sa Pilipinas, meron yung nagre-regulate dyan sa arbitration process na yan. And we are going to talk more about that later on. So sa arbitration, yung arbiter meron siyang power na i-enforce or magbigay ng arbitral award. Okay? So yun, magbigay ng decision. Mr. X, dahil sa kulang yung hindi convincing or hindi kulang yung defense mo dun sa claim mo, kaya ngayon, kailangan mong bayaran si Mr. Y. Pwede niyang sabihin yon. And then, pag nagkataon na ayaw ni Mr. Y na i-respect yung decision ng korte, ng decision ng arbiter, that's the time pwedeng mapunta yan sa korte. Kasi enforceable yung arbitral award na yan. So yun, pwedeng pumunta na sa korte yung decision or para i-enforce nila yung decision ng arbiter. Okay, that's it for med-arb. Next is we have this so-called arb-med, kabaliktaran. Okay? Pero, actually, it is synchronized kasi yan. So, in other words, yan yung tinatawag nila na just simply arbitration. Okay? Kasi, dyan, in arbitration, hindi rin pwedeng maging bias. Okay? Hindi pwedeng bias din yung arbiter dyan. Dapat neutral lang din siya. Yun nga lang, he has the power already to give decision. Okay? Give decision or give arbitral award. So, yan yung sa ARB-med. Just simply arbitration. Kasi yung procedure na pinagdadaanan nila is still just like mediation. Okay? Diba? So, sa mediation, yun lang yung pagkakaiba. The power of the third party. Sa mediation, walang power yung third party to enforce or to give decision. Just simply act as a referee or act as mediator. Pero sa arbitration, the arbiter or the third party has the power to enforce or to give decision or arbitral award. So that is ARB-med. And now, for the number 4, we have the neutral fact-finding or inquiry. So, yung tinatawag natin na mediation. Just simply mediation. So, it is used in many international disputes. And also, it is used for investigation, evaluation of facts before parties decide what to do about them. Okay? So, that's it for neutral fact-finding inquiry and the other alternative. So, those are just some. Next, we have the 5 elements of conflict. So, meron tayong 5. Number 1, needs. What are the reasons why? Bakit kaya tayo ay nakikipag-away or we involve ourselves in conflicts? So, dahil sa pangangailangan, di ba? Dahil sa pangangailangan, inaaway-away na natin ang kasama natin. Okay? Ayaw niyang na tayong tulungan. Let's say, ako, nangungutang ako kay Mr. Iskaran, and then ayaw niyang magpautang. Oh, yun. Ay, gusto ko na siyang patayin. Okay? Or, kung hindi man, Dahil sa lupa, kailangan natin yung lupa, di ba? Isa yan sa kailangan natin, especially kapag tayo ay nagre-rely lang sa farming. So we need to have a land. So yun, dahil sa ito ay inaagaw ng ibang tao, sinasabi na pagmamay-aran nila, but actually it's yours. Okay? That's the time that's the start of disputes usually. We have also here perceptions. People interpret reality differently. So magkakaiba-iba po tayo ng defenses, magkaiba-iba tayo ng pag-iisip. So sometimes it happens yung sinasabi natin na misunderstanding. Okay? And it is also because of power, how we define and use it. So sometimes we involves in disputes because of yun nga, dahil sa tayo ay hindi natin alam kung paano natin makipag-deal dun sa ibang tao. Dahil lang sa tayo ay nasa position, usually hindi na natin naiisip yung sitwasyon ng ibang tao. Kaya nagkakaroon ng conflict. Let's say employer-employee relationship or politician with the residents. Minsan inaabuso ng tao or inaabuso ng politician yung kanyang power, kaya ang ginagawa ng mga tao, nagiging aktivista sila. So yun, they involve themselves with disputes. Okay, nakikipag-away na sa government. And then next, we have values, beliefs, or principles, especially in religious. Diba? One of the reasons why we are still having conflicts is because of religion sometimes, especially with the in Middle East. And then another one, not only religious, not only on religion, but also in the traditions. Or during the long time ago, the reason behind tribal wars because of beliefs, okay, of those different tribes of indigenous people. Okay, and then we have here feelings and emotions affect how they resolve problems. Okay, dahil sa nararamdaman natin. That's why sometimes we involve or we encounter disputes with other people. That's it for the elements of conflict. Next one, we have here the common types of disputes. Number one na dyan, business or employment disputes. So, between employee and employer, or if not, between employees. Okay. So, usually na pinag-aawayan nila, pera, sahod, employer to employee relationship. Sahod usually yung reason kung bakit sila ay nag-aaway. Siguro ang nangyayari, binibigay lang yung sahod. Yung employer, binibigay niya lang yung sahod kapag patay na or malapit nang mamatay yung employee niya. Just imagine. Dinedelay yung sahod niya. So, imbes na ibigay ngayon, hindi pa niya binibigay. So, anong mangyayari doon? Anong gusto niyang mangyari doon sa employee niya? Mamatay siya din sa kanya ibigay? Anong tawag doon? Okay. So, hindi po pwede yun sa mga employee. So, kung minsan nararamdaman na nila they are being abused, that's the time we involved or they started disputes already with their employer. Okay. Another one, employee-employee relationship. Dahil sa yung isa, nagpapakahirap sa kanyang trabaho. Ginagawa niya lahat. Pero yung isa, andyan lang, pa-relax-relax, pasigari-sigarilyo, and so on. So, that is not that could be the reason for some people in employment or business industries to have disputes. And then next is organizational, especially in politics or in our government nowadays. So imbis na sila ay magtulungan, nag-aaway-away or nag-criticize. Okay? They criticize each other. They involve themselves with dispute. Okay? Or it happens that they are still the leaders, but instead of helping each other, they are having conflict. So, siguro it's because of political will. Okay? Or if not, personal reason. So, hindi natin alam. So, that is for organizational. That is just only an example. Next is employment discrimination. So, yun. Related din sa number 1. So, kung saan, minsan na i-scratch yung mga kababaihan or hindi nabibigyan ng tsansa yung mga kababaihan para sa sinasabi nila na equal standards or equal pagtingin dun sa mga kababaihan, especially dun sa mga trabaho, okay, or pag-a-apply ng trabaho. And also yung mga matatanda. But yes, actually in reality, minsan nga naman, syempre matanda na yan, pagtatrabahuin mo pa ba? Pero yun, depende naman yan sa nature ng trabaho. So kung pwede naman ang matanda, why not? You still consider if you are having a business or if you will have a business in the future and you are going to hire an employer. So meron din dyan yung napag-iwanan din, usually mga employees. I mean PWDs. So that is under employment discrimination. And next one is divorce. Okay? So it is conflict or dispute between married couple. Next, for number 5, the post-divorce na tinatawag nila. So yun, sa divorce, it is just the conflict or the dispute between the married couple. Pero dito, involved na yung mga bata. So post-divorce meaning tapos na, naghiwalay na sila. So yung after effects ng divorce, yan yung nandito sa part na ito. So, kanino mapupunta yung bata? Paano yung sustento ng mga bata? So, yan yung sinusolve nila or yan na yung dispute or subject nila dyan sa part na yan. So, that is under post-divorce. Next is on-state conflicts. Ito naman is tinutukoy na yung mga conflicts between brothers and sisters or the siblings usually. So kung saan, kanino mapupunta yung mana. Okay. So, paano yung hatian nung mai-inherit natin. Okay. So, katulad sa bahay, kanino mapupunta itong bahay? Okay. Sa akin ba? Or dun sa panganay ba? Or dun sa bunso? Okay. So, that is common disputes or common here. Or what we so-called dispute. State disputes. So, yan. Next is family. Within the family. So, siguro involved dito yung mga, let's say, work-related problems. So, sino yung nagtatrabaho? Okay, or dahil sa pagod sa trabaho, kung minsan nagkukos ng initan ng ulo between the father and mother. Okay, or dahil sa favoritism sa kanilang anak. Okay, merong favoritism sa mga anak nila. So ito, didepensahan yung isa naman didepensahan yung isang anak. Okay, so that is family, under family. And then land dispute is more on ito rin ay more on mga magkakamag-anak. Okay, so that is land dispute, common din yan. Okay, so let's proceed now with the types of disputes being dealt in court. So ano itong mga litigation, subject for litigations. Okay, usually. So these are the two, criminal case and civil cases. So ito yung usual na pinag-uusapan or sinusolve doon sa korte. Pero yung civil case, some of the disputes before it is forwarded as a civil case, usually nag-undergo din yan ng ADR process. So, yun. Pag nandyan na sa court, tinatawag na yan as a civil case. So, tingnan na natin itong criminal case muna. So, ano ba itong criminal case? It is a type of court proceeding, of course. The defendant is tried, conduct that is considered to be illegal according to the state's legislature. So they believe that the person committed or violated a statute, okay, or batas. So yun, criminal case usually begins when the person is arrested and kapag meron ng naipasa or na-forward ni complaint, I should say, or information dun sa korte. And then, meron din dito yung tinatawag natin na indictment or yung sinasabi natin na formal charge or accusation of a serious crime. So yan, you can initiate a criminal case by indictment or forwarding a formal charge dun sa korte. Or dito sa atin, sa batas natin or sa criminal procedure natin, yung tinatawag natin na complaint and information. But actually, information. Okay? So yun, to compare with the civil case naman a dispute between people. So yun, yung isa, it is not actually a dispute between people with another people. Actually, it is a dispute between the state and then a certain person. Okay, kung mapapansin nyo, di ba sa criminal case, meron yung tinatawag natin na people of the Philippines versus Iskaran. Okay, just like rape. Sabihin natin rape, si Iskaran ng rape. And then lumabas, binasa niya, tinignan niya yung kaso niya. It says here, people of the Philippines versus Iskaran. Nagulat siya. Why? Sabi niya, isa lang naman yung nirape ko, bakit people of the Philippines yung nakalagay dito? Hindi ko naman nirape ng lahat ng babae. Okay, so that is just a joke. But actually, kapag nang-rape ka ng isang tao, parang ang offended party doon is yung state kasi you violated yung batas, okay, na ini-implement ng state or ng government natin. Okay? So, yan. Sa civil case, usually it involves dispute between the different people, between two people, or if not, a person with an organization. So, yan, depende. Whether a natural person against a juridical person, yan is under civil case. Pero yung subject dito usually are financial issues and housing disputes. Okay? Or if not, rights and liabilities. So, sa mga ari-arian. Okay? And then, anything that is not covered by criminal case, those are, or it goes with civil case or considered to be civil case. So, that is the difference between criminal case and civil case. Okay? So, next, we have here the so-called criminal case, or we are going to look deeper on criminal case. So, ano nga ba itong criminal case again? In criminal case, it is also considered that the defendant is always considered to be innocent until proven guilty beyond reasonable doubt by the state prosecutor. Okay, so take note of this. In criminal case, the need or the burden of proof that is necessary or that is needed, take note of the yellow one, beyond a reasonable doubt. You try to observe this, observe the scale. Okay, look at the scale. Is it balanced? Is it well balanced? If you see it, if you take a look at it, it's not, right? It's not balanced. Diba? It's tagilid siya. So yung fino-foresee niyan or pinapakita niyan, the defendant or I mean the weight should be higher than the other. Kasi yung dyan, yung scale niyan, yung tinitimbang niyan is yung evidences or yung proof natin. Okay? Kapag ikaw ay involved in litigation. Okay, so yan, dapat hindi pantay. Kung beyond, di ba beyond sobra. Okay, so hindi dapat just a reasonable doubt. Pag that is just a reasonable doubt, meron pa ring reasonable doubt dyan, that is subject for dismissal. Okay, dismissal of the case. So ang kailangan, let's say in cases of rape, the needed one is beyond reasonable doubt. Dapat mas mataas dun sa scale kung saan nagsasabi na hindi siya yung gumawa ng krimen. I mean, siya yung gumawa ng krimen. Okay? And then, Dito sa kabila, dapat mas maano yung timbang na mas marami yung defense niya na siya ay nagsasabi na guilty or mga evidences na nagsasabi siya na siya ay guilty. So it's beyond, okay? Not equal or not lesser or not just reasonable. Okay, so beyond reasonable doubt. So that is the burden of proof that is needed in criminal case. For civil cases, just the preponderance of the evidence lamang. Okay, so ano ba dyan? More credible and convincing than that presented by the other party. So yun, yung evidences mo dapat mas convincing dun sa mata ng judge kaysa dun sa evidence na pinipresent nung opposite party. Okay, so yan yung tinatawag natin na preponderance of evidence. Okay, so more convincing than the other party. Okay, so that's it. By the way, kapag tinatawag natin na party, hindi po party-party yan celebration, but actually we are pertaining to those persons that are involved in cases. So meron dyan yung tatlo, or dalawa usually, the plaintiff or the claimant or the applicant. So in civil cases, we call them as the plaintiff, yung mga initiate or or makes a claim, okay, nag-initiate ng dispute or claim, okay, or commences the case. So we call him as a plaintiff, a claimant, or applicant. Okay? And then, for the opposite party, ito naman yung kinakasuhan or finailan ng claim is we call him as a defendant or respondent. But actually, in criminal case, itong defendant. Okay? Sa criminal case, plaintiff yung tawag natin. Okay? Plaintiff yung tawag natin dun sa nag-initiate ng kaso. So, the plaintiff usually is the people of the Republic of the Philippines, and for defendant, for the certain person or the perpetrator itself. Pero dito sa civil case, tinatawag natin as respondent. Okay? Yung the one that is defending against the claim. Okay? And for in times na merong appeal na nangyari, okay? In times of appeals, tinatawag natin yung nag-a-appeal as an appellant, and then yung respondent is yung the one that denies the appeal, or the one that is arguing with the appeal. So yan yung different parties that are involved in cases. Next, so ito yung level of required proof. Okay, the levels of required proof. So ang pinakamababa dyan is reasonable suspicion. Okay, so sa reasonable suspicion, the amount of evidence that an officer need to freeze someone. So usually it is applicable on police officers. Okay, so this is a kind of proof in order for them to make pwede nilang kapkapan yung isang tao na nasa public. Reasonable suspicion. So in cases of searches in public. So kunwari illegal possession of firearms. Let's say you are a police officer and then nakita mo si Mr. Iskaran na naglalakad dyan sa park, and then meron kang nakita na hugis baril doon sa kanyang tagiliran. And then ino-observe mo, you take time, you observe him, yung actions niya parang meron siyang minamanmanan or hinihintay. Okay? And then pahawak-hawak siya sa hita kung saan nandoon yung hugis baril na nakikita mo. Okay? Na natatakpan sa kanyang damit. That's the time you are having now reasonable suspicion in order for you to enforce, or in order for you to make search. Okay? So that's the time pwede mo na siyang lapitan and then i-search. Okay, and then probable cause, usually it is needed for issuing or issuance of warrant of arrest. So yun, if the police officer investigator on case prove that there's a probable cause that the crime was committed, the judge will issue warrant of arrest. Okay, and then we have here also the preponderance. It is needed in civil cases. Okay, the amount of evidence is higher. Okay, it is an specific example yung nabigay dito in cases of automobile collision. Okay, so yun dapat mas ma-convince mo or yung proof mo is more convincing na hindi ikaw yung may kasalanan kung bakit nagkaroon ng collision. Clear and convincing naman the amount of evidence necessary for the state to take a child away from the parents. So it is just a specific example, a clear and convincing, or it is needed. It is the needed. It is a proof. It is the proof that it is needed for you or for the state to take a child away from the parent. Okay? In cases of child abuses. Next one is, ito yung pinakamataas, and it is the one that is being it is needed in criminal cases. So, evidence is beyond any doubt based on a reason. So, wala na dapat duda na natitira. Talagang kitang-kita or patunay na siya talaga yung gumawa ng krimen. So that is the levels of required proof. So that ends our video presentation for today. And again, reminder for those who have a question or concerns, queries, you can just comment those queries on our comment section, or if not, you can just save those questions and you can raise those questions when we are going to meet in our synchronous class. And lastly, wait for further announcement, updates in our GCs, and also I will be posting our video presentations, next video recordings for our subject or next topics in our GCs also. Please wait, and then always keep in touch and read instructions or read announcements in our GC. So just simply keep in touch in our GC, and that's it. Thank you for watching.